Hi, thank you for choosing to watch this webinar. In this webinar, I'm going to talk to you about preventing complaints. It's an opportunity for me to share our learning so that you can think about how you're currently providing your legal service. It's important to deal with complaints well when they do arise. However, there are some steps that you can take to avoid them being made in the first place. The Legal Ombudsman began investigating complaints about legal service providers in October 2010. Consistently since that time, the data we collect shows us that the issues complained about most frequently are costs, delay, failure to advise, failure to follow instructions, and poor communication. Knowing this then allows you to take some steps to prevent complaints in these areas. So let's explore them a little further. Complaints about costs have consistently been one of the top 5 types that we see in terms of frequency that issues are complained about. When we talk about complaints about costs, we mean both costs information being poor, but also costs being excessive. There are some steps that you can take at various stages of your involvement in a matter to prevent complaints about costs. They're thinking firstly about pre-engagement. So the foundation of your legal service that you're providing starts before you're actually formally instructed. Your website or marketing materials may provide information that's led somebody to instruct you. And as such, it's so important that that information is clear and does not mislead. When it comes to preventing complaints about this, you'll need to make sure that you're regularly reviewing the information within your marketing materials and on your website to ensure that it's up to date. I'd like to give a case study at this point. So we dealt with a case where the client had viewed the firm's website when looking to instruct a solicitor to act for him in the purchase of a property. The website set out a price match offer if another firm were to provide a lower quote. The client found a quote from another firm for £995 and sent it to the firm that he wanted to instruct. And that firm had the price match offer, expecting therefore to benefit from this. When the matter concluded, he received an invoice for £1,500. He complained about this and we concluded that the firm's service had been unreasonable because the information on their website had been misleading. In that case, the firm agreed to limit their cost to £995. Next, we think about engagement. So your client, when they instruct you, is going to want to know what the total cost of their case is likely to be. We recognise that in some cases it's not easy to provide a precise answer. However, we would expect you to be able to manage expectations in terms of the possible cost range, as well as being clear about how you'll keep that client up to date about their costs. The estimate that you provide at the time of engagement should be the best information that you are able to give at that time, taking into account information and conditions that are specific to the case. When thinking about avoiding complaints about this, try to explain to your client why you think costs will be around that figure, whether there are things that could be done to keep that cost down, and also what may happen to cause that cost to increase. Also be clear about the charging structure and what that means for them, so whether that be hourly rate, fixed fee, conditional fee agreements, for example. You'll know exactly what you mean by these terms, but in order to prevent complaints, it's key that you ensure that your clients also understand. A vital part of engagement is the client care letter that you will send to your client. In order to prevent complaints at a later date because things weren't made clear, you should ensure that your client care letter includes the following: why the client has instructed you, the course of action the client has chosen, what work you will and won't be carrying out, the standards and timescales for the work, the likely cost of the case based on the information within that letter, and where any of this differs from the information on the website or previously shared materials, why that's changed. You need to be satisfied that after reading your client care letter, your client will have a clear understanding of what will be happening, why it will happen, and what the likely cost of that work is. If this is done well, it can go a long way to preventing complaints further down the line. Thinking next about the delivery of service. It's not enough just to agree the possible costs of the service at the outset. Many of the complaints we see are because service provider has failed to update their client about the costs of the case as it progresses. And all too often, service providers fail to give their clients the opportunity to try and control their costs during the lifetime of the service. In these cases, we'll look for evidence that service providers have kept their clients up to date and informed about the costs of a case on a regular basis. We'll also want to see evidence that they have consulted their clients on how to manage potential cost increases or what course of action to take if new options become available. We would expect you to clearly explain the change, any options, and provide cost information about the options. So it's important to consider how well you currently do this. Are you keeping your clients regularly updated about costs? Are you making sure that they're given options for future work and that you're taking their instructions on how to proceed? Finally, in respect of costs, I just wanted to mention enforcement. We recognise that there are cases where it appears that your client is unreasonably seeking to delay paying the bill for the service that they've received. In cases like this, a service provider may want to move to enforce the bill rather than wait for the outcome of the Ombudsman process. We understand that a service provider has the right to seek enforcement of an unpaid bill. However, if a bill remains unpaid, we would expect service providers to give reasonable notice that they intend to seek enforcement. The Ombudsman cannot and will not interfere in a service provider's decision to enforce a bill while a complaint is ongoing. However, where we consider that any action was unreasonable, it will be reflected in the decision we make and any remedy we order. As such, when thinking about how you approach enforcement action, you may want to decide exactly the steps you're taking and the notice that you're giving to your clients. Now we'll have a look at preventing complaints about delay. Increasingly in today's society, we've grown to expect a level of immediacy to our transactions, and a lot of the complaints we see arise from this desire to have things done faster and done now. As a result, we see complaints where there has been a genuine delay, but we also see complaints where there's a perception of delay, and when we look into this further, actually that delay doesn't exist. Looking at real delay, so we recognise that as a lawyer you will have a number of client matters that you are working on at any given time. However, in order to prevent complaints about delay, you need to start with an understanding that to your client, the matter you're working on for them is likely to be one of, if not the most important things to them at that time. In acknowledging this, it helps you then to set clear expectations so that your client is well informed about how long things are likely to take. If you are then unable to meet those expectations that you've set, we would expect to see that you've updated your client in this regard. Delays happen, of course they do, but when it comes to preventing complaints, updating your clients about any unexpected delay is a big step in the right direction. I talked about perceived delay. So sometimes we will see that a firm is actively working on a case and that it's been progressed as we would have expected. Our conclusion, therefore, would be that there hadn't been any delay. However, the reason the complaint has been made is because whilst progress is being made, the client was not updated. Again, I just want to cover a case study in this regard. So I saw a case recently where the client had been told by the firm that 3 key steps needed to take place before proceedings could be issued. After a month or so, the client contacted the firm to ask what was happening with these 3 steps. She didn't receive a response to her email and followed this up twice over the next month with no response. After another couple of weeks, she called the firm and discovered that the fee earner was on annual leave. She raised her complaint at that stage, complaining that despite setting out the steps that needed to be taken, no progress had been made and the fee earner was now on annual leave, having not undertaken the work that was promised. Her complaint, therefore, was about the delay. However, the evidence actually showed us that the fee earner had been working on her case and in fact had completed the 3rd step before his leave. He dictated a letter to be sent to the client on his return to confirm the next steps. There wasn't an actual delay in this case. However, because of a failure to respond to correspondence and a failure to provide updates, the client had a genuine perception of delay and lack of progress here. Thinking about failure to progress. Often when somebody complains about delay, what they're actually unhappy about is the fact that no progress is being made on their case. As lawyers, you'll understand that there are often set protocols to be followed, and things often have to be done in a certain way and in a certain order. However, for your client, they may struggle to understand why progress appears to be slow. So thinking about preventing complaints, one thing you can do is make sure that you're having conversations with your clients early on to explain why things are done in a certain way. It's a common theme when I talk through complaint types that it comes back to communication time and time again, and making sure that things are well explained. As such, the final area that I want to talk about in any detail is complaints about communication. So for a large number of the complaints that we uphold, they link back to communication from the firm, whether that be in respect of costs, legal processes, or even complaint handling. Poor communication is often at the heart of an upheld complaint. Good communication is an absolutely vital part of preventing complaints. It's important to remember that whilst terms and processes may be second nature to a lawyer, a client may have no idea what they mean. Add this to the fact that they're in a position where they need a lawyer, it probably means that they're going through quite a stressful or an upsetting time, and this can lead to a breakdown in communications. So when thinking about communication and preventing complaints, the first thing I wanted to talk about was service level agreements. A lot of service providers will set service level agreements out within their client care letter or within their terms of business. And these often deal with communication. So this may be something like you will always return a client's call within 24 hours, or that all emails received will be responded to within 48 hours. It's really important to set clear expectations in terms of when people can expect to hear from you. However, what we see is a large number of service providers then failing to comply with their own service level agreements, resulting in a complaint from their client. In these cases, rather than the communication itself being poor, the issue is that the way that the service provider is communicating has caused frustration as it doesn't match their own service levels. So, go ahead and set service level agreements, but don't make it so unrealistic that you're setting yourself up to fail. Also, once it is set, you need to make sure that your staff are following this. A failure to do so opens yourself up to complaint. The next point I wanted to talk about was clear communication, and this may seem like an obvious point to make. However, we still see communication that's confusing or contains considerable legal jargon, making it difficult to understand. Using plain English and checking that important messages have been understood can help in terms of preventing complaints being made. This links to the final point I wanted to make, which is making sure that you explain the options. Complainants have told us that sometimes they felt pressured into making decisions, or that they didn't fully understand the process or their options. It's important that as service providers, you're trying to bridge that gap in understanding. So I just want to thank you for watching this webinar. Please see our other webinars for information about the Legal Ombudsman business process, good complaint handling, and how we determine complaints. Goodbye.